Good morning, everyone. Thank you so much for joining us today. My name is Melanie Dawn Molina Wood, and I am the Educational Program Coordinator for Sunbelt Title Agency here in the state of Florida, as well as for Anywhere Integrated Services nationwide. It is my absolute pleasure to be able to introduce Michael Merino today for our program. Michael is a Florida Bar Board certified attorney, and he's been practicing law in the state of Florida since 1995. His firm handles a variety of legal matters, including real estate transactions and litigation, foreclosure defense litigation, condominium and homeowners association law, consumer law, and business transactions and litigation. He is a frequent lecturer on topics ranging from real estate, land development, estate planning, non-resident tax and estate planning, asset protection, and digital assets and cryptocurrencies. So Mr. Merino has offices in Davie as well as in Palm Beach Gardens, and he is available via video conference to you as well as to all of your customers and clients anywhere in the world. He's a member of the Florida Bar Real Property, Probate, and Trust section, and he's also a member of the Federal Bar for the Southern District and Middle District of Florida. And again, with my absolute pleasure, let me turn this program over to Mr. Michael Merino. Thank you, Michael.
So Florida Conveyances to Foreign Entities Act. Let's dive deep into what this law is all about. And the one thing I want to say before I start is that this is a law that there's a lot of unknowns still. There's a lot of questions. There's a lot of things we don't know how to interpret them in the law. I've talked to several attorneys, title insurance underwriters, and the consensus seems to be that we're all flying blind on this thing for now until there's clarification by the courts. Or perhaps the legislature will go back to the drawing board and maybe revise this act to make it more user-friendly. But for now, this is what we're dealing with. And, so let's dive into it. So this is Senate Bill 264. It took effect July 1st, 2023. It's found in Florida Statute 692.201 through 204, and it affects the following countries and persons: China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria. And notably, next in the statute, it says Venezuela, the Nicolas Maduro regime. I've gotten questions from a lot of Venezuelans as to what this means, where they say, well, I'm not part of that regime. And there's nothing in the statute that tells you how to interpret this, what that means. So again, it's one of these things we're waiting on answers to these questions by either the courts or the legislature. So stay tuned. So to give you kind of a general rundown of the law, let's go what it prohibits. This new law prohibits a foreign person who's on that list from buying agricultural land. And when I refer, by the way, to FP throughout the webinar, I'm referring to the foreign persons from the countries of concern. So a foreign person from that list cannot buy agricultural land. Okay. What is agricultural land? Well, it's defined by statute, and generally it's going to be something that has an agricultural exemption, vacant land that you can, I guess, grow on. Again, there's a specific definition on that. And a foreign person, it also prohibits a foreign person from buying property within 10 miles of any military installation or critical infrastructure facility. Okay. And we're going to go into the definitions of what is a military installation, what is a critical infrastructure facility. They also give you this limited residential exception, which says that one of these foreign persons on this list cannot buy within 5 miles of a military installation. Notice that it's only the residential exception only applies to military installations, not to critical infrastructure facilities. It's limited to one home, and it can't be more than 2 acres. Okay. A foreign person from China has the additional obligation of registering the residential property within 30 days of purchase. So the limited residential exception, as it applies to Chinese people, the only difference there would be is that they have to register within 30 days. And then a foreign person can also buy if they're buying for a diplomatic purpose. Now, with regard to the foreign persons buying within 10 miles of a critical infrastructure facility or a military installation, one of the big problems we have is that there's no way of figuring this out yet. And I'm going to go over how that is. But the other thing I wanted to point out is that this is not a law that's really necessarily unique to Florida, that this is in the federal legislature and Congress. They've been talking about ways to limit foreign countries from buying in the U.S. And I'll give you a couple examples. In North Dakota, the Chinese bought a big chunk of agricultural land right next to a military facility. So North Dakota is now looking into laws to stop that from happening. And then in Arizona, the Saudi Arabians somehow purchased a big chunk of land to build alfalfa sprouts, as well as the water rights. And think about this. In Arizona, they have water shortages, and now you have a foreign country who owns the water rights. So again, these are some of the reasons why these laws are being passed. And it's not unique to Florida. A lot of other states are talking about it. And on the federal level, they've been talking about it for a while. There's also another issue, which is foreign landlords. And I'll give you an example. The Social Security building, I believe it's in Arizona, is owned by a Chinese group. The FBI building, I believe in Phoenix, is owned by Koreans. So there's this thing where there's a lot of foreign landlords, some from hostile countries, that own buildings in which the U.S. government is a tenant. Again, for spying reasons and things like that, these are issues. So there's a lot of legitimate public policy reasons behind these laws. But, again, in Florida, this one that they passed is a bit confusing and still has a lot of questions that are unanswered. So what is a critical infrastructure facility? It means a facility that uses fences, barriers, or guard posts that are designed to exclude unauthorized people. So again, it's not just a critical infrastructure facility, but it also has to use fences and barriers to exclude people. Examples are chemical plants or refineries, electrical power plants, water treatment plants, liquid or natural gas plants, a port, a seaport, a spaceport, or an airport, or a telecommunications facility. Now, the problem we have is that nobody knows where these things are. I mean, there's some research that you can do to try to find them. You, by the way, as realtors, should not be trying to, figure these things out for now until we have more guidance from FREC. The recommendation is to make sure that you refer them to an attorney to figure these things out. So that is the definition of a critical infrastructure facility. And then a military installation is any base, camp, post, station, yard that's at least 10 acres. It's got to be at least 10 contiguous acres, and it's got to be under the jurisdiction of the Department of Defense. Okay. And again, the big problem with this is that there is no searchable database yet. That's what we're hoping will come out. There's no database or method of determining the proximity of a property to a critical infrastructure facility or a military installation. So it makes it very difficult. So again, as I mentioned in the beginning, we're sort of flying blindly, because it is very difficult to determine how far something is from a critical infrastructure facility, or whether the critical infrastructure facility fits the definition. Does it have fences? Does it have guard posts, etc.? I pulled a couple things from the internet to kind of illustrate the difficulty of this. Here's a map. Again, this is just for illustration purposes. It's not for you to try to figure out where how far a property is from a military base, but this gives you an idea of all the military bases that there are. Tampa, of course, has got MacDill. Here in South Florida, we got Doral, Southern Command, which is not even on this map. We have the U.S. Coast Guard, the Homestead Air Force Base. But throughout Florida, as you can see, there's a lot of military installations. We got to figure out, we're going to have to figure out some sort of a way to punch in an address so that it can tell us whether we are close to these things or not. Here's a map of some power plants that I found online. Again, this is just for South Florida, but you can see, there's quite a few of them. And this is just power plants. This is not chemical power plants. It's not water treatment plants. I did a list of some of the South Florida airports. I mean, here in South Florida, I didn't do all Florida, but just to give you an idea, in South Florida alone, we have about almost a dozen airports that we have to worry about. Military bases. I mean, they're all over South Florida as well. Critical infrastructure. We got an FPL plant, Port Everglades, Port of Miami, Turkey Power Point nuclear plant. So again, these are just a few that I found online. There's tons of others that I just don't, it's just almost impossible to figure out. So let's talk about some of the other definitions. A foreign principal. Entities, it means an entity from one of the countries of concern owned by a foreign principal or government or political party of that foreign country. Individuals or any persons who are domiciled in a country of concern who are not a U.S. citizen or resident. And controlling interest is something that they don't define in the statute. They just say if somebody has a controlling interest, but it doesn't address what about a manager managed LLC where the manager makes all the decisions, but maybe only has a 10% interest. They don't have a controlling interest in terms of membership units or shares, but they control the company by virtue of the management. So again, unclear. We don't know. They do define de minimis interest. It says that you can have a de minimis interest, which means less than 5% or less of a publicly traded company, or if the equities are registered with the Securities and Exchange Commission. Also, inherited or property acquired by foreclosure or debt collection, the foreign person who acquires that property by inheritance or by collecting a debt like foreclosure has to sell the property within 3 years. Civil and criminal penalties. So the law imposes civil and criminal penalties for violation. For land purchases near a military installation or critical infrastructure facility, it's a second-degree misdemeanor. For Chinese land purchases, the penalties are a little stricter. It's a first-degree misdemeanor if you knowingly sell. So if you're a seller and you say, I'm going to sell it to you anyway, you could be guilty of a first-degree misdemeanor. And other violations of the law are considered third-degree felonies. And this only applies to the Chinese portion of the law, the felony part. So, again, it's not really evenly applied. So I'm sure there's going to be some constitutional challenges to it. I think there already is, actually, which we'll go over. The state of Florida also has the power to seize and lien land for violations of the law. So if you don't, for example, if you don't register the property, they can fine you $1,000 a day. If you don't pay the fine, they can lien the property. If you don't pay the lien, they can foreclose the lien and seize the land. So the property that's acquired before July 1 must be registered with the Florida Department of Economic Opportunity or the Florida Department of Agriculture, depending on whether it's agricultural land or any other type of land. And the deadline for registration is January 1, 2024. Most of my foreign clients who have called me, we've kind of said we're going to hold off on the registration for now until we kind of get a better feel for how the courts are going to interpret this, whether this thing is stricken down, whether there's an injunction. Again, a lot of unknowns yet that we're just trying to figure out. A foreign person can purchase one residential property, as I mentioned, that's up to 2 acres if the property is not within 5 miles of any military installation. If the foreign person has got to have a valid U.S. visa that is not a tourist visa. Again, this is another area of the law that we're unclear on. It doesn't list the type of visas. Is an L1 okay? Is an E2 okay? Is an EB5 okay? Again, it's unclear, but it seems most attorneys that I've talked to seem to be interpreting this law as saying that if you can live here legally and be a resident here legally, even if it's with an L1 or an E2, then this would apply. You would be able to exercise your rights here under this exception. The property has to be in the name of the foreign person holding the visa. This appears to mean that you can't use a corporate entity. And now this becomes a problem, and I don't think they thought this through very well, but Venezuelans, Chinese people, Syrians, Iranian, anybody on that list who buys real estate without being able to put it in a special type of corporate structure is exposed to the estate tax. And the estate tax, avoiding the estate tax legally requires not just one company, but 2 companies. It requires having an offshore so you can avoid the estate tax legally. Well, that option is no longer allowed. One of the foreign people on this list can't use that option anymore. So they're exposed to the estate tax. And those of you that don't know about the estate tax, it's about 40% of the value of the property at time of death. So a Venezuelan person buys an expensive property in Tampa for $1 million and they pass away, they're going to have to pay the U.S. government $400,000 approximately. So again, it's a problem. The Chinese requirement for the residential exception, it's exactly the same, except that if you're Chinese, you're required to register within 30 days of purchasing the property under the residential exception. Agricultural land, let's talk about that. No foreign person can buy, inherit, or devise, meaning give it by will, agricultural land, except they can have a de minimis interest, which we talked about is 5% or less of a a company that trades on the exchange, or 5% of a registered a property that's registered. I'm sorry, a project that's registered with the SEC. A foreign person who acquired the land before July 1 has to register it, or they're going to be fined $1,000 per day. You can't buy more land either. If you already own it, you can't buy more of it, and you have to sell it within 3 years if you owned it before July 1st, 2023. If a foreign person on the list acquires through devise, through a will, foreclosure, or debt collection, they have to sell it within 3 years of acquiring it. They're also required to sign an affidavit at closing that the buyer is not a restricted foreign person. And the failure to obtain the affidavit does not affect insurability of title. So, it's one of these things where the affidavit is required under the law, but if a title insurance agency doesn't get the affidavit, it doesn't affect insurability, at least not yet. Failure to register, as I mentioned, is $1,000 per day, and any land that's acquired in violation of this law can be seized by the state. The next bucket, again, there's a few buckets. One of them is the agricultural land. The second one is land that's near a military installation or a critical infrastructure facility. No foreign person can buy, inherit, or devise, meaning give it away by will, within 10 miles of a military installation or a critical infrastructure facility, except they can have a de minimis interest. Okay, so again, less than 5%. A foreign person who acquired land within 10 miles of a military installation or critical infrastructure facility before July 1's got to register it with the Department of Economic Opportunity, or they're going to be fined $1,000. They cannot acquire more land. A lien can be filed and the land can be seized. An affidavit that buyer is not a restricted foreign person has to be signed at closing. And again, the residential exception allows one property, no more than 2 acres, and it's got to be more than 5 miles from a military installation, and the person has to have that the visa allowing for residency. And they have to sell it within 3 years if it's within the 10 miles, the forbidden zone, as I call it, or if it's acquired by a foreclosure or debt collection. An affidavit, of course, is required at the time of purchase. FREC is required under the law to create this form, but I haven't seen it yet. So I'm not sure what FREC is waiting for. My guess is that maybe they're waiting for what we're waiting for is court interpretation. What's the federal government going to do? What's our state legislature going to do to fix things? Maybe there's going to be patch legislation. We don't know yet. So it says that the affidavit is required at the time of purchase, which most of us are interpreting as at the time of closing. And again, FREC's required to provide this form, but we don't have it yet. So there is no case law on this yet to guide us through the interpretation of the law. So we're kind of waiting on some guidance from the courts and to see how the courts interpret it. There is a new FAR-bar contract clause that it is above the signature line. It discloses the existence of the law, and it suggests that the buyer obtain legal counsel if they are a foreign person of concern. It advises that the violation of the law is a crime, and it also advises the foreign person that they have to sign an affidavit. This is what it looks like, and it's in a little box right above the signature line. And for now, I think the best bet is to, not ask people, where are you from? Just show them this box. I think that some of the companies I've seen, including Caldwell Banker, have come up with some new disclosures that you can give in addition to this disclosure in the contract. Now, the other thing that this brings up is fair housing issues. Is it discrimination to exclude certain classes of people from obtaining housing? Well, most of the case law says yes. Is this law constitutional? It remains to be seen. But again, from most of the attorneys I've spoken to, the consensus seems to be that, as written presently, it's likely not constitutional. Does the law violate civil rights? Again, probably yes. Are contract rights unconstitutionally impaired? The answer is probably yes. And think about this one. You went into a contract as a Venezuelan for new construction a year ago. Now, by buying this property, you're in violation of the law. So I think, yes, that would be an impairment of contract rights. And again, it would be impossible for that Venezuelan person to perform under the contract, because if they do so, they're breaking the law. The Department of Justice has filed a statement of interest in federal court arguing that the law violates the 14th Amendment Equal Protection Clause and the Federal Fair Housing Act. A group of Chinese people have also filed suit in federal court arguing that the law is discriminatory, unconstitutional, and violates the Federal Fair Housing Act as well. So depending on how these challenges play out, we'll probably get some sort of interpretation of the law, and it'll probably go back to the legislature and maybe they'll tweak it. Maybe it's stricken down altogether. But again, that remains to be seen. For now, it is the law of Florida, and we got to make sure we're aware of it and abide by it. This is what the affidavit looks like that was produced by one of the title insurance underwriters. That basically it just says that that the person signing it is in compliance with the act because they're either not a foreign principal or they meet one of the exceptions. Okay, so what's the advice? The advice is don't discriminate. Treat all buyers the same. Don't ask buyers, are you Chinese? No, I'm Korean. Or you don't need to ask all those types of questions. Refer people to the FAR bar clause or to whatever disclosure that's been put out there by your company. Suggest that the buyers get legal counsel. That would be a good one. Don't exclude foreign persons in MLS remarks. In your broker remarks, don't say no Iranians or no Cubans or Chinese people or anything like that. Of course, you don't want to do that. Watch for predator lawyers. Okay. Yes, some of my colleagues are out there, going like, okay, now who are we going to sue? So they send testers out to say, I'm Venezuelan, or I want to buy, and the realtor asks, well, are you Venezuelan? And then you get sued for fair housing violations. So beware of these testers. They're out there. I suspect we're going to see more of them, and stay tuned and stay informed. Because this is a fluid situation. And again, hopefully we're going to have a little more guidance from the courts very soon. If anybody has any specific questions that they want to talk to me, maybe in a private conversation, that's my phone number. There's my email address. Feel free to give me a call or shoot me an email. I'll be happy to answer any questions that you might have. And this is our last slide. And that's for you. I guess if you want to provide some feedback, you can do so there in the with the QR code. So thank you all for participating, and anybody has any questions, we'll be happy to answer them now.
And we do have some questions coming in, Michael. And please, if you enjoy this presentation, please do take just a couple of minutes to take the survey and let us know how much you absolutely love Michael and want him back on every topic we can get him for.
You can, feel free to use words like, breathtaking, amazing. I couldn't stand how awesome it was. No, I'm just kidding. Be honest.
and compliment the photos too.
Right.
So a couple of questions that have come in already. Well, number one, just to clarify, did I understand you correctly that you will provide me with the deck? You said you needed to.
Oh yeah, of course. Yeah, there's a couple typos I'm going to correct, and I'll send it over to you so you can distribute to anyone who wants it.
Perfect. So we will definitely do that if you've attended here today. And then we did have a question. Do you know how this situation is going to work if it's a married couple purchasing a property and one of them being a U.S. citizen, not from any of the ethnic groups that we're discussing here, but the spouse definitely does qualify as a foreign national from one of these areas?
Well, I mean, if they're married to a U.S. citizen, the presumption is that they have some sort of a process in place. And the real question, I think, would be is, where are they in that process? If they have a temporary, residency, for example, they're probably okay. But again, the statute does not distinguish between these things. I've gotten a question the other day about dual citizenship. Same thing. Whether somebody's got dual citizenship, it's not. They don't distinguish in the statute. And most of my colleagues that I've talked to are taking the position that if you have dual citizenship, this law applies to you. And with the married couple, it's going to really depend on where they are in the process. If they, just got married and they're waiting on the status to be approved, it's probably going to depend on that. But again, another question that difficult to answer. I hate to say it, but I don't know. I'm not afraid to say I don't know. And that's just really the reality of it. Is a lot of these things we just don't know yet. Understood.
Is there any discussion or anything in the statute that discusses what would happen to the commissions In other words, gave that example of the Venezuelan that was under contract to buy
New
a new
construction.
construction.
Yeah, that's a good question. Again, an impairment of a contract, and I think the position I would take there on behalf of a realtor would be that we did our job, and we brought you the buyer, and we're entitled to our commission. But of course, the Lennars of the world will likely argue that this law has impaired the contract, and therefore, because they can't have a sale, that no commission will be paid. So again, another one where it's going to be up to the courts to decide really how a contract between a realtor and a builder will play out, or any seller who's offered a commission, or broker who's offered an offer of compensation through MLS, how that will play out if the contract is impaired and you can't close because of this law. Again, this one is going to be another one for the courts to decide, or for the legislature to go back to the drawing board and put some exceptions in the law that will clarify some of these issues, and that being one of them.
Is there anything in the law or anything right now, again, pertaining to those commissions, if a buyer refuses to sign the affidavit at closing?
Well, again, the insurability of title is not affected by the affidavit. If somebody, it's a requirement of the law and the buyer doesn't want to sign it, I mean, it's on the buyer. I would say that's a breach of contract by the buyer, because presumably the buyer is signing a contract that includes the disclosure above the signature line. So if it includes the disclosure above the signature line, which warns the foreign buyer that if you don't sign this, you're going to have to sign this affidavit at closing, and then they get to closing and say they don't want to sign it, it would be just like any other document they're refusing to sign. They'd be in breach of contract, and they would be subject to being sued by the seller.
Understood. And to that disclosure and or the change on the contract itself, my understanding is most of the brokerages here in the state of Florida that I have talked to agents from, Sotheby's, Remax, all of those, you mentioned Coldwell Banker, pretty much all of them do have some sort of a disclosure already, as well as what is in the contract. So if you're not sure, please reach out to your broker manager and double check what your brokerage is offering on that. So are there any penalties to the real estate agents themselves if there is any kind of a mistake made? And I'm not talking about the issues that we're talking about with fair housing. We don't want to ask those questions, but if we don't ask those questions, then we could conceivably put a buyer into a position.
Again, the contract warns the buyer that they're going to have to sign an affidavit, and that affidavit is what protects really the realtor at closing, because the affidavit, they're saying either it applies or it doesn't apply. And again, it lists which countries they are right on the contract. So, but in terms of penalties, what the statute refers to as knowing violations, meaning that you wink, wink, let's not tell anybody you're Chinese or something like that. And don't worry, I'm going to help you do this. And, a realtor who's facilitating, a deal knowing that they're helping violate the statute. Yes, there's going to be penalties. They're going to probably be subject to, civil and criminal penalties for violations of the law. So the key thing is not to knowingly try to assist someone to get around this law. And as long as, realtors are not doing that, I think that, there's really not a whole lot to worry about. It's the knowing violations that are a problem, and that those are the ones that are mentioned in the law. Yeah.
And then kind of the flip side to that is, if a buyer were to volunteer that they are from one of the countries on the list, how should a real estate agent respond?
Well, if they say, yes, look, I'm from Venezuela, then you maybe just let them know that show them the disclosure that you have either in the contract or whatever additional document that's been produced by your agency, and let them know that you recommend that they get legal counsel. Look, it's not unlike, listen, when somebody says I'm a foreign seller, the first thing that should go off in your head is FERPTA. Okay, that, oh, there's FERPTA issue. And so what do you do when you identify a FERPTA issue? You say, hey, you need to go check, meet with an accountant or a lawyer to help you, with this FERPTA process, because I'm a realtor. That's not something I do. The same thing you would do, if there's an electrical problem, let's call an electrician. So I think that if we identify that somebody is from one of these countries, what they should be doing is referring them to legal counsel. For at this point, all we really have to go on is a legal opinion, where a Venezuelan or Chinese person would go to the lawyer, and the lawyer would produce a legal opinion to determine whether or not this law applies, and to do some due diligence to determine whether the property in question is close to what the proximity to that to any of the critical infrastructure facilities or military installations, how far they are. But that's what I would recommend.
And I will absolutely reinforce that. We as realtors need to stay in our lane, refer these types of questions over to the attorneys. And you do have Michael's contact information if you need to recommend one. I want to clarify the way the question came in. So I think we need to have some clarification. The foreign owner registration, does it apply to all foreigners, or just if the owner is from one of these 7 countries?
No, it only applies to the foreign persons of concern, or foreign entities of concern that are on the list. Those are the ones that would need to register.
And do we have any idea where they are supposed to go to register?
Yes, there's 2 places, and it depends on what type of property is. For agriculture, it's going to be the Florida Department of Agriculture. Everything else, commercial properties, etc., residential, would be registered through the Florida Department of Economic Opportunity.
All right. And then I believe at the beginning of the presentation, you said that there are or may be coming somewhat similar laws in other states and or at a federal level. Anything as, how can I put this politely, either as draconian or as confusing as Florida's?
Well, you know what, I haven't really followed closely what other legislatures in other states are doing. Okay, hold on a second. Sorry, I just got some kind of weird message on about my computer getting ready to restart from Microsoft. So if you lose me, that's why. I haven't really followed very closely the legislation in the other states. I have followed, though, on the federal level what they've been trying to do, and there are a few bills that are are being debated that have to do with the foreign landlords and and things like that. I haven't seen anything on the federal level quite like this, or I'm not aware of anything in another state that's quite like what we have in the state of Florida. But again, they're being debated throughout the country. I know North Dakota is probably the one that comes to mind first. I know that they've been considering this type of legislation if they haven't implemented it already. But yeah, I'm not sure about.
All right. So I do have a couple of comments here. Awesome presentation.
Thank you.
Breathtaking, with 3 exclamation points.
Thank you.
I'm just looking to see what else we've got in here. A lot of great presentations, things like that.
Oh, great. Thank you.
Lisa suggests this might be a great opportunity for the real estate agent to do a buyer consultation and use that opportunity to provide these disclosures. What do you think about that?
Yeah, I think that, again, I mean, this is about, educating them and pointing them in the right direction. So, yeah, I mean, I think that any opportunity that you have to, meet with a buyer and, show them that clause. Oh, wait a second. I'm half Venezuelan and half Iranian. What do I do now? Or, well, you point them to the legal counsel. Now, one thing I wanted to mention that I think that is important, because it's something that that's come up recently, which was, we want to make an offer right away, and the person's from Venezuela. What do we do? And so one of the things I've been suggesting is a contingency. I mean, we come up with another contingency that within 10 days after the effective date, the buyer, shall have the opportunity to determine whether or not the law is applicable or not. That's about the only thing I've been able to come up with lately, to give us a little bit of breathing room so that we have some time to make that determination, because there is nothing in the form contract or any riders they've come up with makes it contingent. So, that would be something that would be helpful. And again, I would defer to your brokers on this as to what, how they want to come up with in terms of this type of contingency.
That actually sounds like a good suggestion, but I agree. Definitely, everyone that's on this call, they need to go back to their broker managers, and perhaps the brokerage
and somebody
attorneys will
just
come up with
mentioned,
something.
sorry, somebody, Lisa just mentioned, yeah, you could also use the attorney review rider, I suppose, and say, hey, we're going to give the attorneys a little time to review this without mentioning the law. So that would be another way to do it. If you wanted something more broad, you could just do the attorney review, which I know a lot of people don't like the attorney review because, of course, the attorneys, as they say, we don't want the attorney to get a hold of it because they're gonna make all kinds of comments on our form contract, which, by the way, I try not to do. I don't like to reinvent the wheel. I think we have the FAR bar is actually a pretty good balanced contract.
But Lisa, I think that is an excellent suggestion, at least for the time being. If there's a possibility of this law affecting one of our customers' clients. There was a question again about the dual citizenship.
Yeah, and I've gotten that one a few times. Yeah. So dual citizenship, again, is not addressed in the statute. But, again, if the one I got recently was they had Italian citizenship, but they also had Venezuelan citizenship. And I guess, unless you only have the Italian citizenship and you're a Venezuelan living in Italy with Italian citizenship, I think it's going to apply. And again, until we get more guidance from the courts, or we, the legislature reworks this law and gives us some more guidance, again, it's an unknown, but I think I'm erring on the safe side and proceeding with caution and advising people that if you have dual citizenship, this law will apply to you.
Angel, you were asking, what can I share online? But I'm not entirely sure I understand exactly what you're asking. Are you asking, can you share information about this law, or are you talking about sharing this presentation? So if you could clarify that for us, I'd appreciate it. The law. So Angel's asking, what can he share as information to his market about the law?
I would share the copy of the disclosure that appears in the contract. I would share whatever other disclosures, hopefully written in their language, if language is an issue, that have been created by, your, Coldwell Bankers, your broker's office individually. And then, you could also share a copy of the law, just like they do with landlord tenant. When you do those residential leases, you're required to share a copy of the landlord tenant law. It really is not a law that is, hundreds of pages. It's actually pretty manageable in terms of the length and being able to read it. So yeah, you can share a copy of the law. And again, I would defer to your brokers as to whether or not that's something that's advisable or not. I personally don't see really an issue with sharing the law. The law is public record. You can do that. But to the extent people are going to read it, are going to understand it, that's a whole other issue.
I would certainly suggest sticking to the facts and sharing the documents themselves. Be very, very leery of expressing any sort of an opinion one way or the other about this, and certainly be very, very careful not to step into the side of advising at all. Certainly check with your broker without a doubt. So
good advice.
All right. So overall, I think that we have gotten to all of the questions here.
Okay, excellent.
So I'm going to thank everyone for joining us today. I learned a lot, and perhaps am more confused than I was when I started. That has nothing to do with Michael and everything to do with the questions that we still have about the law itself. So Michael, thank you so very much for
my pleasure
this morning.
My pleasure. And anybody who has any questions, feel free to reach out.
Absolutely. And I did put your information in the chat a couple of times.
Okay, excellent.
Nivea is asking, so I'm going to ask you right now, put you on the spot. Can you come back and give us an update once Florida figures out a little bit more
Oh
what
yeah,
we're doing.
absolutely. Well, I will definitely be doing an update because I've been, again, I've been following it pretty closely. So once I have some more information, we determine what's the outcome of some of these cases, we'll definitely give an update because that's going to, again, allow us to better interpret the law and, and how to deal with it and how to move forward. So absolutely.
Excellent. We did have another question. Can we share the presentation itself?
Sure. Yeah. I mean, I'm okay with it
Michael
if
says
you'll.
that's okay. I would please check with your broker first, though, because again, we don't want to be saying anything that would be different from what your broker may be saying. We also don't want to be putting you as the real estate agent in any kind of a position of appearing to give legal advice. So Michael says it's okay if your broker says it's
If you want
okay.
to share it, yeah, it's fine with me.
And then we do have one more last question here. What if the
Sure.
buyer asking to translate the disclosures as they do not speak English?
Well, again, I think that this is really more of a broker question as to what their internal office policy is. I mean, I would think that it's probably a good idea to take the time of, each individual agency to have these things translated. I don't think it's a good idea for you as an agent, if you speak Chinese or Spanish, to sit there and try to interpret it, because again, that could be construed as, hey, you told me this, and maybe it wasn't the correct interpretation. Let them decide for themselves. Let them read it in their own language. There's always Google Translate, I suppose you can let them know, but I think that you're better off having some, professional translation, and that's something you want to probably talk to your individual broker about. And of course, it'll depend on what, I guess what volume you have of foreign clientele. Like here in South Florida, we have quite a bit of Venezuelans, Cubans, Russians. And so, in South Florida, it'd probably be a good idea to have them in all those languages.
And we might also, I haven't heard anything coming out of the local or state Realtors Association. I do know for like contracts and things like that in the past, they have provided translations, which cannot be used as the contract, but can be used to help our foreign buyers. So maybe let's all give them a call and ask for this disclosure to be translated for exactly that reason.
And call FREC, everyone, and tell them where are our procedures. By statute, they're supposed to give us the procedures to follow with this law and the affidavit. And so, they're a little behind. We haven't gotten it yet. So again, we're all just waiting here for FREC to deliver, and they have not yet. So I would welcome any phone calls, a little nudge.
A little bit of realtor activism will come in handy here.
Right,
So yes, call FREC, and let's call FAR as well, and see if we can get these things so that we as the real estate agents can feel a little bit more comfortable that we are adhering to the law as best we can.
That's right.
All right, so we are just about to the top of the hour. So again, Michael, thank you very, very much for joining us. My pleasure. Today.
Nice to be here with everyone.
Yeah, it was a great group today. So we had a good class.
Excellent.
And again,
all right,
I ask you to give us some feedback on the class itself, and we will go ahead and end the meeting at this point in time, if I didn't do it already.
Thank you, everyone. See you soon, Melanie.
Bye-bye.
Have a good one. Bye-bye.